Hello, everybody. I'm Doreen, and today we're speaking with Frank Sisson III. Frank is an attorney who practices law in Connecticut, New York, Florida, and New Jersey. And after years of working as legal counsel with other prestigious firms, Frank opened his own practice, Sisson Law Offices, in Westport and Stamford, Connecticut. During his career, Frank has concentrated primarily in the areas of estate and trust and related tax planning. How are you today, Frank?
I am doing great, Doreen. Thank you very much. I hope you are the same.
Thank you. We are. And thank you so much for joining us. I know you're super busy and you're squeezing me in, and I really appreciate that.
Never a problem talking with you, Doreen, but it is very busy times for us estate planning attorneys, for sure.
Yeah. So I wanted to ask you about that, Frank. Like right now and during these last 6 months, it's hard to believe it's been 6 months already, 7
Sure.
almost. What are you experiencing to be your clients' most pressing concerns on the top of their minds?
Well, needless to say, we've had a lot of people updating their estate plans who we've seen in the past. This is on everyone's mind with all the horrible news about the virus, COVID-19 issues, and respirator issues, and just horrible stories. People have this on their minds, and they're thinking about their own families, their own situations. They don't want to burden their families. They want to make things easy. Nobody's expecting the worst, but it's just in the air. So as a result, a lot of people updating their estate plans with particular attention to the living will document, which has to do with life support systems and what your instructions might be if that hopefully very unlikely event were to come to pass. And just in general, estate planning, distribution plans, trusts, how to reduce probate complications and delays. That's bringing people back that we've seen before. But we also have a lot of new clients who really kind of put wills and estate planning out of their mind, as we all like to do most of the time. But it's something that you feel better and less stressed by doing it than by putting it off. So we have a lot of new clients calling and asking for simple or more complicated planning to get those documents into place. More recently, Doreen, we've seen an increase in people calling worried about the very likely change in exemption levels for estate taxes. If there is a change in administration, right now we've got a federal estate tax exemption of $11.58 million per person, which for most of my clients is a safe harbor that they're in. But if we have a change of administration, there is talk that may well go down to perhaps as low as $3.5 million per person, which is a lot of money for most people. But in Fairfield County, Connecticut, and this general area, it's not that hard when you start adding in life insurance and the value of a home in Fairfield County, even after a mortgage. It is a net figure, not a gross. But it is on people's minds as well with the headlines. So that's driving people in as well, because they know that this is their time to act and that it may be too late if they wait until 2021.
Okay. And you mean because after the new administration?
Yeah, because it's not possible to transfer assets out of your name once the exemption is in effect at a lower level. You can't take advantage of the high exemption we have now. But if you beat the clock, so to speak, get your assets transferred to your children or to a trust for family members ahead of the change of the exemption, that could be a very valuable step to have taken.
Okay. Can you help me, and I think probably a lot of people out there, understand a living will, from a high level?
Yeah, a living will, which I think is a terrible name for it because it has very little to do with living. And people are calling my office all the time asking for a living will when what they really mean is a last will and testament. So it's confusing to have that word will in both documents. A living will, though, is, we used to call it, when I first started my practice, a death with dignity form, or a final directives form.
I like that.
It has to do with decisions that you would not be in a position to make because when this becomes relevant, you're not capable of communicating. Basically, we're talking about a situation with a coma or a very serious illness where you've lost your capacity to communicate. And if the doctors have concluded that there is no chance of reversal, of course, that's relative, it's a human decision, but they're pretty careful, very careful. This directive, we call a living will, is a statement to the world, mainly the medical world, that you do not wish to be kept on life support systems indefinitely. The science has gotten so good. I actually had a client family in our office where one of the family members had some very difficult brain surgery, had never come out of that surgery consciously, and was in a coma for 7 years. She had not signed a living will. The family had to live with that situation for 7 years. She was biologically alive, but not really alive in a quality of life sense, but they couldn't do anything because she had not signed a living will. So it's a thing we don't like to think about too much or too often, but by not dealing with it, you may be creating massive problems in the future for your family in a hopefully unlikely event that it becomes an issue. So I don't know if that's enough of a explanation for you, but all states permit it. Connecticut has its own state-approved form. Some states don't have a state-approved form, such as New York, but Connecticut does. It's a very good form. The thing I like about the Connecticut form is it does permit you to name a family member. We call that person a healthcare representative. Doesn't technically have to be family, but usually is. And that person must consent to the doctor's decision to suspend life support systems. So I call it a lock with two keys, the doctors being one key, the family representative the other key. Both keys have to turn. So that's the living will. I think Connecticut has a very good approach. New York has a slightly different approach, but I do New York planning as well, and we use a form that's suitable for that state. And it's something you have in your file. You can always change it. You can always change the people you name to be your representatives. You can revoke it altogether if you decide you'd rather not have a living will in place. But it's something we all should at least consider.
Let me ask you something about what you said, because it piqued my interest. With sadly, this woman who didn't sign a living will. I would think with health insurance and everything the way it is these days, that the hospital wouldn't, or the insurance companies would no longer support, what it takes to keep a person who hasn't signed a living will alive.
Yeah, it's a good point. And I don't know what I don't think it's possible for the hospital to suspend treatment for financial reasons, for the same reason they can't turn people away from an emergency room. There's got to be some public support, some absorption of costs in cases where the family simply cannot pay. I believe that same standard applies to the hospitals. Now, whether the insurance companies cut them off at some point is another issue. You'd have to consult with other experts to explore that. But it's a good point. But in my practice, in my experience, I've not heard of a case where someone has been suspended on life support because of financial problems that have restricted availability of funds.
Okay, that's interesting. But I would imagine if you get cut off from an insurance point of view, that could bankrupt a family.
That's very, that's very good. And the family I'm talking about with the 7-year coma, they lost about half their assets once the insurance was capped out and the deductibles had been, used up and the coverage was used up. They went through about half their assets. At some point, the patient simply didn't wake up one morning. At some point, even the machines can't keep you going. So it's a point. And I've had a couple of clients actually have me write. You can alter the state form. They've had me write into the state form a clause indicating that if the financial strain to the family becomes an issue, if insurance stops covering, they want that to be taken into account in the family's decision to consent to the termination. So it's a relevant question, very relevant.
That makes good sense to me. I mean,
Yeah.
that's just such a tragic situation to be in. Can you help us understand a will versus a trust?
Sure. A will is a document that ultimately goes into a probate court and is an official statement that the person is making as to distribution of their assets in their own name, and the selection of representatives, usually an executor, sometimes a trustee under the will, if there are younger children under 18, a guardian. These are all very important decisions that need the formality and assurance of that formality in a document that the court can look at and approve. That's the will. A trust is a broader term. A trust can be established under a will. It can be set up during your lifetime as a separate self-standing document. It can be used for purposes of holding educational funds. Grandparents or parents can set aside funds for that purpose. Very broad legal concept, does not involve automatically a probate court, but can. The probate court has jurisdiction to hear problems concerning trusts. But very useful part of my practice in estate planning, the trust. And we often use trust to reduce or avoid the complications of probate, perfectly legally with the blessing of the probate court system. But property in trust, when one passes away, goes immediately to the beneficiaries, or perhaps held in trust for a further term for the beneficiaries, but without the involvement of the probate court system. So it's an alternative to a will, really, is a good way to think of it, and also has broader application during lifetime if you wish it to.
And there's revocable and irrevocable, correct?
Correct.
And
yes.
what do you recommend for your clients?
Well, I like the use of a revocable trust in most estate plans because it does give us the flexibility of allocating some assets to that trust and keeping them out of the probate process, which will save a lot of time and complication. Also very useful for holding out-of-state property. If you have an inherited vacation or family home, or you bought one, for whatever reason you have, even a timeshare can be real estate in some states. Those will trigger a second probate proceeding if you're not careful about it. If you pass away with that kind of an asset, of a real estate asset in your name in another state, you will have an ancillary or secondary probate proceeding in the other state. Use of a living trust, a lifetime trust, to hold title to that property is a way to avoid that, because the trust, unlike us, will not die. It may terminate, but it will not die. So the trust would continue to be the owner, even if we lose the person who made the trust. So very handy for that purpose. We use irrevocable trust, the other version that you mentioned, to achieve a tax planning objective. For example, life insurance can be placed in an irrevocable trust and moved out of one's taxable assets. There are some catches. You have to survive 3 years beyond the date of the transfer. And life insurance is particularly useful because it has very limited, if not zero value when you transfer it in, but high value if and when it comes into effect with a loss. So it's a way to move all of that asset value out of your name and into a separate vehicle, an irrevocable trust for your family that you control through family members being involved in management. So irrevocable trusts can be used for that purpose. We can also put other kinds of assets in irrevocable trusts. But remember that a transfer to an irrevocable trust is a form of gift, so that we have to contend with gift tax laws and limits and taxes that can kick in with that kind of planning, with gift-oriented planning. With a good professional, you can overcome those concerns and know what you're getting into and what you're achieving. But that's my main use of an irrevocable trust, is for tax planning.
Okay. So if you have clients who don't have a will, or don't have a living will, or don't have any of their assets in a trust, what do you recommend? I mean, especially now, what's your counsel? If there's people listening who have none of that?
At the very least, put a simple will into effect. If nothing else, you can choose guardians for your minor children, and you can avoid what they call the probate bond requirement. A probate court is required to impose a fiduciary probate bond on every estate that does not specifically waive that requirement. There are some exceptions. The judge can independently determine that the bond is not necessary, but why take a chance? So it's so easy to sign a simple will, preferably with the help of a professional. There are some canned wills out there I'm not a big fan of, but they do exist. But you can easily appoint a guardian, waive the bond requirement, and also indicate your choice of executor, the person who would be in charge of managing your estate. And finally, if you have children, even adult children over the age of 18, if you don't think they're ready to handle all assets without some help, you can include a trust for them, perhaps up to age 25 or 30. Many of our clients worry about early first marriages maybe not working out, which statistically is the case. Mm-hmm. And you can help your children by not releasing funds to them, certainly not at age 18. I think that personally is too young, but it is permitted by law. They would be legal adults. So yeah, at least a simple will. Now, that's my minimum recommendation, but I would prefer people coming in to adopt. We have 5 documents that we like to recommend for new clients coming in for estate planning. One is a power of attorney, a durable power of attorney. That's a lifetime document, but it's quite handy if there were ever an accident or an illness that made it impossible for you to carry out a necessary action with an investment, a bank account, an insurance claim. Even things broader than that, access to files, dealing with your cable company. This allows you to appoint someone who can act while you're living in your place, sign your name, and take action for you. There is a duty of fiduciary responsibility involved, so you must act in your best interest, but it's a handy document to have, particularly recommended for people with elderly parents, people getting up there in age at least, because things happen, and it's just very useful for someone younger in the family to have that capability. So power of attorney, document number 1. Document number 2, healthcare proxy. That would allow you to appoint someone to make medical decisions, even in a short-term context. If you're under anesthesia or in an operation and something comes up that needs decision, multiple options for surgery or treatment or prescriptions, that person can be your voice while you're not able to make your own decision, rather than leaving it to doctors you don't know. They can seek the advice of the doctors, but at least you have someone who knows you involved for you. So that's the healthcare proxy. In that same form, we usually do include the living will we talked about earlier. There is a combined form available to us in Connecticut that's quite good. So we would include that living will in the healthcare proxy form. The third document we like to see is a HIPAA medical file access authorization form. The HIPAA laws, federal laws protecting the privacy of health information, are quite strict. The doctors are all aware of them. They will not share information with even other close family members. The spouse does not have a right to medical information on his or her spouse automatically. But with a HIPAA authorization form properly prepared and signed, we can open that door to them and avoid a stonewalling situation. We usually include spouses, at least adult children. Often now we include teenage children or younger, but perhaps restrict their access to verbal information only on status and condition. Handy thing to have. Now you can always, on an intake interview with a hospital, provide them with a list of names that you're okay with having access to information and communication. But if you don't have a chance to do that, you're traveling, there's a 911 situation, this document is critical to avoid that very difficult situation. And it's very common now with parents of college-age children. They won't think about these things. Something might happen in the campus hundreds of miles away, and the parent will not be told what's going on because the child is over 18. So we have a lot of parents of college-age children coming in just before the first semester begins, asking for those documents for their young adult children. Suddenly they're adults with their own independent rights, and it's an important thing to get ahead of. So that's the third document, and the last two would be the simple will, sometimes not so simple depending on the situation, and the revocable living trust. We increasingly recommend that. It's not absolutely necessary, of course, but it's a very handy thing to have to reduce complications of probate. Also to have available as a beneficiary for life insurance and IRAs, 401k plans. You have to be careful because there are strict rules with IRAs and 401ks about what a qualified trust must contain, but we address that in the trust document we use. And it does avoid the situation of having an 18-year-old suddenly coming into a lot of money with no management structure around it, because with use of the living trust as the beneficiary, we have an older, usually family member trustee looking out for the child and managing that fund until they're of the right age that you have decided is the right age of maturity. Often we'll see installments, maybe a third at 25, another third at 30, the rest at 35. Those ages are all arbitrary, the fractions are arbitrary, but each person has a pretty good idea of what makes sense for them. And of course, with the living trust, revocable trust, you can amend it as time goes on and you see the child develop. So just to recap, the 5 documents: a durable power of attorney, healthcare proxy, HIPAA authorization, access form, the last will and testament, and the revocable trust, sometimes called a living trust. Those are the key documents I consider to be very important for anybody with any kind of asset base, planning their families and their own future, and just being on top of this. I like to comfort people by reminding them these are not documents we plan to use tomorrow. This is not our plan A. They're what I call umbrellas in our legal closet that are there for a rainy day we hope is not going to come around for quite a while, but you'll be very happy that umbrella is there if you need it.
Right. Frank, that was such a great, thorough answer. And as much as we don't like to talk about it, we do have a beginning and an end. And
Yeah.
we need to prepare for that. So, thank you so much for that answer. It was so thorough. I took notes. So I appreciate that. We have about 6 minutes left, and there are a couple of questions I want to ask. And one of them is, so with that time in mind, in terms of refinancing on mortgages, I know you help people with that.
We do
And
that
due
as
to
well.
the low interest rates that we're seeing now, how do you advise people in terms of refinancing?
We handle the legal end of the refinancing, so we're not brokers. We don't put them in touch with the lenders. But once they have their lender, I tell my clients absolutely refinance if it makes sense. And the rates are at historic lows. I'm not sure where they are today, but they have been at historic lows for about 2 months now. And we can take an existing mortgage, pay that off with the funds from the new mortgage, and have the client now with that lower rate going forward for as long as 30 years. So it's if there are costs involved in the refinancing, often they're more than reimbursed in the first few months of the new mortgage, just simply from the reduced monthly payments. You can often go a little bit higher on the new loan amount and avoid any out-of-pocket costs altogether. You simply put them on the back end of the new loan, and you really don't notice them. The prorated amount over the number of months of the loan for the closing costs makes them almost invisible. But there are banks out there and institutions that will give you incentives to close, maybe give you some help with a credit towards closing costs. The rates do differ bank to bank. You have to ask. You can pay some points and get an even lower rate than perhaps the market would give you if you don't pay the points. And that's just crunching the numbers. I would recommend you work with your financial planner or a mortgage broker to determine if that's right for you. But once they have settled on the lender, we in my office closes for almost all lenders. And it's just a matter of getting the closing scheduled after the lender has approved your financial situation, and the mortgage loan on your property always involves a new appraisal, of course. They want to know that the property that is collateralizing the loan is sufficiently within the range of safety for them for the new loan they're making. But it's a very good thing to do. And you have to jump on the opportunity when it exists. And right now it does exist.
Mm-hmm. Before we move on to the last question, I just have another little question. I know I'm cheating, but just real quick, are you meeting with new clients virtually, or are you meeting with them in person?
Oh, that's a very good question. I should have gotten into that earlier. We're doing a lot of remote signings these days, Doreen. It is permitted by law as of April. The state of Connecticut issued an emergency order that permits remote notarizations. And also there was a second order a short time after that permitting attorney supervised will signings over the internet through a video platform such as Zoom. Not the only one, but probably it's the one we use, and it's a good one. It's really helped a lot of people. Before they passed that order, we developed a concept we called front porch signings. And I would go over to the home of the client with very safe spacing, stay on the front porch, leave the documents on a table, back away, allow the client to take the documents, sign them while I'm watching, and we got the signing done that way with complete safety. But the remote procedure is even better because I can, just as I'm speaking with you remotely now, you could be signing a document, I could take your notarization over the internet, and it would count the same as if you were in my office. It's not an e-signing, it's an ink signing that is remotely supervised. There's a distinction. You would sign in ink. And I would get the documents from you either by mail, by drop-off, by pickup, any number of ways. There are some requirements for a remote notarization. You have to deal with a licensed Connecticut notary, of course. You have to have your driver's license available and hold it up to the camera so I can confirm your identity and have proof of that. You have to confirm you are in the state of Connecticut physically when you sign. Finally, you have to get an electronic image of the document, at least the page you signed, to the notary, in my case, myself as an attorney notary, that same day. But we satisfy that by simply having the client hold the signature page up to the camera after they've signed each page, and that counts. So it's pretty painless. The one non-painless thing for me is that I have to keep a video recording of the notarization for 10 years. So that's my responsibility, but we've got an arrangement that works pretty well. It's totally confidential. Nobody sees that recording. I suppose it would come up if someone challenged the validity of the document. That's very, very rare. We would have it to demonstrate in that very rare instance. But that's available to us now, the remote notarization and the remote will signing, second order that was issued by the governor's office, has the same status as the statute of law. We can supervise will signings over the internet through the Zoom process as well. And I can have a witness either with me in the room I am in, the client in their own home, or I could have the witness available through a second Zoom connection. And I've done it both ways, and it works very well. And I like it because it removes any issue of safety concern for the client, also convenience. Many people are home with their children these days. It's hard to get out. It's not always safe to get out. It's just a great thing the state of Connecticut has done to allow this to be an option for us now.
Okay. Last question. We have 1 minute.
Okay.
During this time, which I'm sure is very challenging for you and for all of us, where do you get your inspiration from?
My inspiration, well, first of all, it's in my nature to enjoy helping people. Enjoy might not be the right word. It makes me feel good and serving a good purpose to be helping people. And I think these are particularly stressful times. If I can help people remove some stress by these remote procedures, by helping them overcome concerns about wills and trusts, to know their family will be okay, that's something worthwhile for me. My other more specific inspiration is the next generation. I've got 2 daughters getting married in the next 3 months.
Wow.
And, I think of them and their families to be and their world, and I want us to be okay. I want us to get back to normal, and whatever I can do to carry us through these difficult times in a good way is also worthwhile. So those are my inspirational thoughts at the moment.
Well, Frank, you're such a good man, And thank you so much for taking the time to help people understand these very important aspects of life from a legal point of view that, you know, we all need to look at and make sure that we've got buttoned up. So thank you so much.
Well put. You're quite welcome.
It's always a pleasure to see you and hear you and to be with you.
Thank you, Doreen.
Thank you.
Thank you so much, Doreen. All right. Have a good day. Take care. Stay safe.
You too. Be well.
Thank you. Bye-bye.
Bye.